So I am so happy to be here with you today. I am no longer a federal prosecutor. I joined a law firm and joined the private sector about 5 months ago. But for 18 and a half years, I was a national security prosecutor. And most recently, for the last 4 years, I was the national security chief at the U.S. Attorney's Office for the District of Massachusetts. Prior to that, I served in the Navy JAG. So if anyone has any Navy vets in the room, thank you for your service. And I wanted to give you my perspective about the DOJ's Civil Cyber Fraud Initiative. Well, I will say from my experience being a national security prosecutor that what we heard from Colonel Frost there's a tremendous threats out there, primarily from cyber criminals and from the nation state actors. And my focus of my 18 years was really China, because that is one of the biggest national security threats that we face and will continue to face in the future. But China, Russia, Iran, and North Korea are conducting aggressive cyber operations against the United States. And so one of the things I wanted to talk to you today is about the importance of a strong cybersecurity program that you, and talking to your clients, you don't want to be the soft target. I've prosecuted both terrorism and counterintelligence violations, so espionage, export violations, sanctions violations. But I'm going to use today the soft target model, because I think that is really what we're talking about and how the government has started looking at counterintelligence and cyber as the next most important program and part of our ecosystem. And the national security ecosystem, it relies upon our cyber networks, and we really need to fortify those for the future. I'd like to begin, and by the way, I do have to say something, because earlier I was listening to Nick Del Russo, who's excellent, obviously, but when he said, you know, we are overclassifying, and if we don't, you don't have to protect it unless it's CUI. For the love of Christ, you have export control information sometimes in your systems. You need to protect that too, okay? Let's just take that. I just want to put that, let's mention that, because, so you have ITAR and you have EAR. Those are 20-year felonies if you illegally export them or you have a deemed export in your facility. All right, so now I can move on. Sorry, I had to just digress for a second. Okay, that's me, you know that. Okay. Moving on, and now I'm at Hinckley Allen, and there's my information. My information's in the context too. So I want to give you some background as to what was going on that led to Executive Order 14028, because I think it's really insightful for you to understand. And so in 2021, there was an escalation of cyber attacks. We all know that. We had the solar winds, you had the Colonial Pipeline. And by the way, that picture of the ship, that's actually Martha's Vineyard, the steamship authority, because I'm from Massachusetts, and so I had a Massachusetts picture in there. But it's the Nantucket and Martha's Vineyard Steamship Authority. Also had a ransomware attack right at the beginning of their busy season. That was not good, and that affected some of the politicians too, by the way. So they got to feel some pain. And then they had the cyber attacks were hitting hospitals, which of course is dangerous, and I think someone coined the phrase killware for those attacks, because people die or could die. So and the problem with those cyber attacks, amongst other things, was that the government felt that they were ill-equipped to respond. They couldn't respond because the private sector was not providing them information. They were not reporting the cyber attacks. So they wanted, basically the outgrowth of this, the result of these attacks, was the Executive Order 14028. And I know in the defense industry you have Section 7012, but the majority of companies out there they're not legally required to report cyber attacks right now. Obviously, there's the new law that came into effect earlier this year. CIA, the cyber incident reporting law. And I use the acronym, I'm sorry, but I'm a former military person. It was just easier for me to remember the acronym than the long name that I have in one of my slides. But that's going to require reporting of cyber attacks within 72 hours and ransomware payments within 24 hours. But that's not yet effective because the law gave CISA 2 years to come up with regulations to go along with it. So the reason, my understanding is most of you all in the room don't work for the primes. They're the mid-size and smaller companies. And I was told I needed to explain to you why you should care about the Civil Cyber Fraud Initiative. And what this slide, I think, really is, epitomizes the threat, right? Cyber criminals are not going to be going after many of the primes because they have higher walls, right? Higher fences and more layers of security. They're going to be going after what? The softer targets. And so that's where they have been focusing their efforts. Now, does that mean they're not going after the bigger targets? Yeah, the nation states are going after the bigger targets, but you have to worry about all the cyber criminals out there who are just greedy and want to make fast money. And those might be going after, likely going after the mid-sized companies and the smaller companies. So they're targeting people down the supply chain. And that's why cybersecurity is so important to that group. So Executive Order 140/28, it was designed to protect our nation's cybersecurity. It actually was issued again because of the perceived inability for our government to respond to cyber attacks. That was the reason for it. Looking at how does the country encourage more people in the private sector to report cyber attacks? Called for bold action as to what do we do and what's the coordinated response. Asked all federal agencies to go through and figure out, do a comprehensive cyber review. What can we do at each different agency? And what happened as a result of this was that there, as everyone's heard in the news, multiple agencies are coming out with things that they want to do in the cyber arena, right? You have the DHS Cyber Safety Review Board. You have the SEC coming out with new rules on cybersecurity. They're proposed right now, but they're going to be fundamental changes for public companies as to what do they have to disclose and when. And then with regards to DOJ, FTC also started looking more closely at labeling of products. What are the cybersecurity advertising on products, on the software? I think there's been a lot of talk about the software bill of materials issue. So there's all these things that really, I believe, stem from this executive order. So in October 2021, DOJ announced the Civil Cyber Fraud Initiative. Lisa Monaco, the DAG, the Deputy Attorney General, announced it. And it was designed, regardless of what you've heard about this Civil Cyber Fraud Initiative, it was designed to change behaviors. That is my belief on this. And we know that from her press release. There's a press release. Also, there was a press conference. Excuse me, I watched it. And her words were very telling. For too long, companies have chosen silence over reporting cyber attacks. So the primary purpose of this is designed to require companies to report cyber attacks. And the DOJ is going to use the False Claims Act, something they've used for years, since the Civil War, actually, it's a civil enforcement tool to pursue government contractors and grant recipients that fail to follow cybersecurity standards. They will be held accountable for putting U.S. information and systems at risk. So we also know from the public statements, there's 3 common cybersecurity failures that are going to be targeted under this new initiative. They're not only providing deficient cybersecurity products or services, not only misrepresenting cybersecurity practice or protocols, i.e. 7012 and the various bids when you file them, the assessments, when you say, oh, I actually, this is my score when it's inaccurate or not well documented. And then the third one, and this again, I think this is going to be the focus, and I think the cases show that, knowingly violating obligations to monitor and report cybersecurity incidents and breaches. And why do I think that's going to be the focus? Because that is the purpose. It goes to the heart of national security, and that is the purpose for which they issued Executive Order 14028, and why DOJ announced the Civil Cyber Fraud Initiative. Sorry, I'm going to move my slides here. I got it caught up in my moment here. Okay, so False Claims Act. So what is the False Claims Act? I assume that most of you are not lawyers. You're like, what the hell is this False Claims Act? Okay, so it is a civil enforcement tool. What does that mean? You're not going to go to jail for that. But my last slide will show you what you could go to jail for, which is related. Not you, you're specifically, and I'm not going to put any of you in jail, but remember, I'm not in the government anymore. But what your companies could end up being found to be criminally liable for, individuals could be held liable for. And when we're on the subject of individual liability, this Civil Cyber Fraud Initiative coincides with a new focus of the Department of Justice, which is white-collar crime. White-collar crime is just another word for corporate crime, by the way, but that's what you'll hear. So they've decided that they want to target companies, and they want to bring more investigations and more prosecutions, and they're not satisfied by high-dollar corporate settlements. They want to see people go to jail. They want convictions. So just have that in the back of your mind when you're talking to people back at your companies, if you're a consultant talking to companies. That is what DOJ wants right now. That is, they've said it multiple times. So we have that False Claims Act. And what does the False Claim Act prohibit? It prohibits submitting or causing the submission of false claims to the government for payment. And materially false statements. So you make a material false statement, your contract officer asks you a question, and someone in your company responds. And in that response, it's false, and it's material false. Materiality, by the way, is a very low bar. There was a lot of debate. There was a recent case in DC talking about materiality and how hard it is to prove. It is not hard to prove at all, by the way. I mean, honestly, when I was a prosecutor, it was like, materiality, I'll just throw one witness on and we'll show materiality. And why it is when I say that is all that you have to show is that it had the ability, the capability of influencing a decision maker. That is the definition of materiality. And typically you would put like, say if I had a lot of false statement cases, some of them related to the Boston Marathon bombing. There was a number of individuals that lied during that investigation and obstructed the investigation. We would put up an agent. So if he had said this, well, how would that have affected your investigation? Oh my goodness, it would have done this and that. And so what I'm saying is materiality is not a very high standard. And we all know from all of the pronouncements from DOD recently that cybersecurity is what? Material. DOD just released a memo about having 7012, how the importance of it, and that cybersecurity is material. I think that really resulted from the Aerojet litigation, because that was one of the issues that I'll get to in probably 10 minutes or so. But that was one of the issues that they were trying to dismiss the case, Aerojet, based on the facts that cybersecurity wasn't material, and they lost that. So it's an extremely broad statute, applies to anyone who causes false statements or claims to be submitted to the government. The examples, I give you a list of examples because I think sometimes it's hard to think about this without having some examples, but it starts at the bidding process. And earlier, Jacob had mentioned section 7008, and that basically in that section of the DFARS, it says very clearly, by making the offer, you are attesting to the fact that you're going to implement the cybersecurity requirements in NIST SP 800-171. So that's the issue. All right. So once you send that offer and you are basically asking, you're saying offering to provide these services, making your proposal, if it's accepted, you are then bound to meet those requirements. And if you fail to do so, that is a false statement. That's a false, and when you ask for payment, that's a false claim. Because by asking for payment, you're impliedly certifying that you met the material requirements of the contract, when in fact, you may not have. If you submit a SPRS, with the SPRS system, the supplier performance risk system, if the number that you put in there is inaccurate or you can't document it, that's a false statement. That's false as well, and that could be the grounds for a False Claims Act. And thinking about the correspondence, and any correspondence with the contract officer, that could be false. But essentially, those are the examples there for you of what the False Claims Act, what the basis of a False Claims Act action could be based upon. So what is unique about the False Claims Act is it has a whistleblower provision. That is not in many statutes. And what the whistleblower provision does is it provides a financial incentive for your employees, the insiders, to report to the federal government when they think that you're not complying with cybersecurity standards, when you're not reporting a breach. And that they're using that provision very aggressively. In every press release related to the Civil Cyber Fraud Initiative, they mention that. They encourage the whistleblowers to come forward. And there's many that think that the recent settlements will embolden whistleblowers to bring these actions. 900 new whistleblower actions were opened in FY 2020, and then you see on the picture on the slide came from DOJ's website. Showing the amount of settlements, 5.6 billion in settlements in FY 21, and the total since 1986 is $70 billion. Now, so what is the financial incentive? So the whistleblower, if the action, so let me just take a minute and just explain how this process works. Whistleblower, oh, by the way, there's lawyers out there that specialize in these cases. So you go to one of those lawyers, they file, and I'm not saying they're bad, I'm just saying that's an industry within the legal community. I'm not one of those lawyers, but certainly I know people in that industry. So they bring the action, they say, this is what my company did to me. Typically, often, they've been fired. That's a very bad idea. Do not retaliate against a whistleblower because that is another cause of action. But okay, so they come to the lawyer, say, I have this action. It's filed, the complaint is filed under seal to the DOJ or U.S. Attorney's Office. The prosecutors then look at it, and they do their own investigation and figure out whether they're going to join the false claims action. Sometimes they do and sometimes they don't. If they join it, they intervene in it, and they become a party to the action. If they don't, the whistleblower is authorized to continue the suit on behalf of the United States. And then, if there's a recovery, they're successful, they get 15 to 30% of the recovery. The recovery is not just the actual damages, it's the actual damages times 3, because there's treble damages. They also are entitled to attorney's fees on top of that recovery, and there's also civil penalties, ranging from $12 $12,500 to $25,000 per claim. To give you an example, in the Aerojet case, they were seeking damages of $19 million, and that was the cost of basically all the claims that were filed under what they called the fraudulently obtained contracts. And so that's how that works. So just going back for just 1 second. So DOJ, remember, part of the cyber fraud initiative is to change behavior. So yes, while they're going to go after anyone that has lax cybersecurity standards, they really are trying to encourage reporting of cyber attacks so that they can respond to cyber threats. That is the real purpose behind. That's my belief. No one's told me that, but that's my belief as to why the Civil Cyber Fraud Initiative was put in place. Let's turn now. I want to take some time to talk to you about some of the settlements and basically how not to become a target, a DOJ target. So the first settlement under DOJ's Civil Cyber Fraud Initiative came in March of 2022, and that was the Comprehensive Health Services LLC. They agreed to pay $930,000 to resolve FCA allegations. Now, many of you will be saying, there's no way, well, maybe some of you, but there's no way that this case was brought after the Civil Cyber Fraud Initiative. And you're right, it wasn't. Although DOJ is saying this is the first settlement under it, but the case had started long before the Civil Cyber Fraud Initiative was announced. CHS was a provider of a global medical services company. They provided services in Afghanistan and Iraq. And it was discovered that, well, the allegations were that CHS did not maintain patients' medical records on a secure network. They also failed to take adequate cybersecurity steps to protect patient information. So that was I think this was gravely concerning to the United States because, medical information has a lot, we've been talking about a lot of defense information, but this is intimate details of what medical conditions you have and information, medications you're taking. And in the United States, it's all covered by HIPAA. And overseas, they decided to bring a false claims action. And it's clear from this case, and there was other aspects of the case, I'm focusing on the cyber pieces, that the DOJ will aggressively, and this is what they said in the press release, they will aggressively pursue government contractors that fail to follow cybersecurity standards. In this case, and this is a recurring theme that you'll see throughout these cases, is that employees brought the cybersecurity standards, the problems, the concerns about what was going on to the company's attention, to management in the company. And they disregarded it. So 2 whistleblowers actually initiated this case, but the company did not do anything. And one of the takeaways I'm going to repeat over and over, but this is the critical piece of how to protect your company from cybersecurity, from a false claims action for cybersecurity non-compliance, is to have a hotline where people can report these things, provide training, lots of training on cybersecurity, make sure your employees know that you take cybersecurity seriously, because that will could be instrumental in making sure that these false claims action cases are not brought against you. But if you don't listen to your folks, you don't investigate complaints or concerns, that could lead to a false claims action, as many of the cases illustrate very well. So CHS wasn't the first cybersecurity false claims action settlement. Does anyone remember Cisco from 2019? So Cisco, now that was prior to the Civil Cyber Fraud Initiative, but I thought it was important to remind everyone there was a fairly large settlement, $8.6 million Cisco paid to the government to pay for allegations stemming from their sale of hackable video surveillance gear to the US government, to the US government agencies. You could hack it. I mean, we're relying on our companies, and we got sold hackable surveillance equipment. In that case, similar to some of the other cases, the employees raised concerns to the government, to the software engineer reported to Cisco management. The products were riddled. That was basically the definition, the description, riddled with serious security defects. And Cisco did nothing for years to address it. I think it was 4 years. 2009 was when the initial report was made. 2014 is when they publicly disclosed. So, and with regards to this, so you understand the settlement, 2.6 million was paid, Cisco paid to the federal government, 1 million of which went to the whistleblower, and 6 million went to 46 states. Because as I'm going to explain, 6 million to 15 states. The next case is 46 states. 6 million to 15 states. So these actions are not just federal actions. They could also be initiated by states' attorneys general. So that's another concern that you should have going forward, because now this is something that is various state attorney generals have voiced concern. Cybersecurity is a hot topic, probably evidenced by the fact it's in the news almost every day with a new hack or a ransomware attack. And so there is a lot of concern about protecting consumer information and protecting our government network. So as the Cisco settlement illustrates, state attorney generals could also institute actions against companies with weak cybersecurity. Cisco could have avoided liability, as I just mentioned, if they had just listened and conducted an investigation, reported the problems, and addressed them in a timely manner. They didn't do that. They covered it up instead. That is always, if you talk to any lawyer, they will tell you the cover up is always going to get you in more trouble. And you might not even face liability if they addressed it immediately. But they failed to report it or remedy the security flaw for years. And again, this is a recurring theme and problem that results in significant liability. Now, moving just recently in June 2022, Carnival corporation agreed to pay more than $6 million to settle lawsuits. And this was 46 states. They waited 10 months to disclose a cyber attack that occurred in May of 2019. The largest of the fines was $5 million, and that went to New York. That's where they're headquartered, by the way. The New York State Department of Financial Services has very extensive regulations. And they found very problematic the fact that Carnival had 4 cyber attacks within the span of 2019 and 2022. So in the span of 3 years. And 2 of them were ransomware attacks. And when they did an investigation, they found that they didn't implement MFA, something we've heard a lot about, that CISA says is one of those really, at a minimum, please implement MFA. And New York has similar regulations. They also found that they didn't report the cyber event, and they didn't conduct adequate cybersecurity training of their personnel. So, as I said, I promise, Aerojet. There's been a lot of discussion about Aerojet over the last year, and what an important case it was. This is the second settlement under the Civil Cyber Fraud Initiative. So I want to take a few minutes to talk about this case in the context of the Civil Cyber Fraud Initiative. If ever anybody is really interested in reading more about the case, the opening statements from the trial were fascinating. I read them. It was fascinating and horrifying at the same time, because if you know what Aerojet, the type of work that Aerojet does, it's an aerospace and defense contractor, but it builds, very highly sensitive rocket engines for missiles and rockets. And they were, as a result of their work, they were given access by DOD to highly sensitive missile tech data. Okay, by the way, that's ITAR. Okay, just so I remember we talked about ITAR earlier. Just wanted to just make sure this is clear. Okay, so you have this really important sensitive stuff that Aerojet is, basically they give it to them. They promise they're going to implement cybersecurity, and the promises that they made, and this is what the whistleblower complained about, Brian Marcus, is that they're going to implement cybersecurity standards. This case was from the contracts that are issued were from 2013 to 2015. So the DFARS 7012 clause required implementation of cybersecurity controls contained in NIST 800-53. And I mentioned that earlier during my question of Jacob. So Brian Marcus says, and by the way, so they certify, we're going to implement these security standards, these cybersecurity standards. They didn't. So Marcus's basically FCA action, the whistleblower, was that they lied to obtain these contracts. That was the basis of the lawsuit. So I'm gonna step back and tell you the facts, and we'll go back. We're gonna go back and forth here. So Brian Marcus was a senior director of cybersecurity, compliance, and controls at Aerojet. Prior to that, he worked at Raytheon for 10 years as a cybersecurity director. So when he comes into Aerojet, he has knowledge. I mean, they hire him to be their cybersecurity director. And he says to his CEO, we're gonna have to spend $2 to $5 million because we are not meeting the standards. And this is a company at the time that was making over 1.7 billion in revenues. And the CEO says, we're not spending that. We're not spending that money. And so do what you can with the budget that we have now. And I don't remember, and I don't think it was in the papers that I read, the amount, but it was $2 to $5 million. And then you see in the slide, it was $9 million settlement. So maybe they should have spent the money. All right, so moving forward, so Brian Marcus, he says, okay, and he tries to do his best. He basically is a whistleblower. He says, we can't, I cannot certify that we are implementing cybersecurity controls and that we've met them. The contracts required Aerojet to meet 60 of the 253 controls in 800-53. They met 5. And we know that from, they actually hire Ernst & Young as to do an audit, and the auditor says, this red flag, this is critical. You need to fix this now, and they did not. And they did tell Air Force contract officer, we're not meeting them, but we're meeting the majority of them. We're not meeting all of them, but we're meeting the majority. Well, I know, I became a lawyer because I'm not really good in math, but 5 is not a majority of 60. I can do that. So I think everybody can understand that, right? So anyway, the case, he files the case after he refuses to sign the documentation saying that, certifying that they're implementing cybersecurity measures and meeting the cybersecurity measures of the contract. He's fired. Again, very bad idea. Okay. So then he institutes the False Claims Act case in 2015. It remains sealed for a few years while the government, the DOJ, is deciding whether they're going to intervene. They decide that they're not going to intervene, and the case is unsealed in 2018. 2 weeks after the Civil Cyber Fraud Initiative is announced, DOJ files a statement of interest explaining why the contracts were material, the cybersecurity provisions of the contracts were material, and the fact that they did, in fact, the government did have damages, which assisted the whistleblower in defeating what's called a motion for summary judgment. For non-lawyers in the room, there's typically different stages of a lawsuit. There's a motion to dismiss stage, where the defendant can file a motion seeking to dismiss a case. And then if they lose that, they typically file what's called, after discovery is done, documents are reviewed, depositions or interviews of witnesses are conducted, they then have another opportunity at the summary judgment phase of a civil case to file, basically a motion saying we should win. The case should be dismissed and you should find in favor of the defendant. The judge denied that motion and the case proceeded to trial. Oops, sorry. It's not moving on. Wait a second. It says I have to reboot. Your workstation has been updated by Summit 7, and a reboot is necessary. Can we bypass that? Oh, wait. Remind me in 20 minutes. All right. Okay, I got it. Oh, okay. Thank you. That always happens, right? Okay. So this was the first of its kind cybersecurity non-compliance FCA case to get to trial. So they overcame the motions to dismiss and for summary judgment. I want to just take a minute, though. I still have time, yay. To explain the materiality and damages issues of the summary judgment case, because I think it's really informative about going forward. So Aerojet says, these weren't material. No one's complying. Jacob said this earlier. No one can comply with these requirements. And by the way, we told the Air Force contracting officer that we weren't complying with all of them. The judge that rejected that, saying, no, you didn't tell the government about the true scope. The true scope of the problem was that there were cyber breaches. They didn't know, they didn't have an inventory of their network. So when their network was breached, they didn't know which information had been exfiltrated by the hackers. And by the way, one of them was a nation state actor, Russia. So Russia essentially got the missile tech data that was on their system. So that was extremely problematic. And I can't believe they even went to trial. Okay, and then next, damages. They said, but Your Honor, you all are my judges here. Your Honor, we produced functional rocket engines, and that was what was required under the contract. And DOJ, in their statement of interest, says, no. We contracted for you to maintain our tech data on a secure network, subject, and that it would meet certain cybersecurity standards, which it did not. So we didn't get what we paid for. And that's exactly what the judge found. So that issue of materiality and damages then went to the jury. It was going to go to the jury. And less than 24 hours after the jury was impaneled, after the opening statements were made, and I really thought they were, that the plaintiff's attorney, the relator's attorney, did a very good job of juxtaposing the type of work Aerojet was doing with the significant cybersecurity failures and the exposing of our data to the Russian government that could use it, basically undermine our systems and put our troops at peril, essentially, because they could undermine, the system no longer is valuable because now our adversaries knows how it works and could disable it, essentially. So they decide after the opening statements, the second day of trial, to make an offer. They settle it for $9 million and undisclosed amounts for attorney fees and for a wrongful termination claim. So we don't know how much more that they paid. Of that recovery, the relator, the whistleblower, got $2.61 million, which was 29% of the recovery. Now, if you look at the press releases announcing these settlements, you will see that DOJ here again is highlighting, that please, whistleblowers, they're highlighting the important role that whistleblowers play because they have inside information and asking them, please identify any knowing violations of cybersecurity failures. Recently, just last week, the DAG, Lisa Monaco, the Deputy Attorney General, made a speech and she was highlighting this settlement and the importance of the settlement. So how to avoid becoming a target of DOJ's civil cyber fraud initiative? Well, you need to implement a strong cybersecurity program. You have to ensure that it incorporates the requirement of NIST 800-171. And just, one of the things that I was reading a book recently that someone recommended to me on cybersecurity for businesses. I can't remember the title, but it's excellent. I will make a picture of it and post it if someone's interested. But it was looking at cybersecurity from it's not just an IT problem, people. It's not just that one segment of your corporation has to look at it. It's throughout the whole enterprise. Your CEO, your managers, everyone needs to be concerned about this. And you need to regularly update it. It's not just a compliance problem. It's a national security problem. It's an economic security problem across your company. Our supply chains, this is critical. And I know I'm speaking to the choir here, but I'm just going to show. So I get very animated because I just think it's so important. And provide, as I said, provide extensive training about cyber controls. Make sure everyone knows the importance. It's not a one-day-a-year training. You need to make sure that your folks know how critically important this is to our national security and economic security. China is trying to steal our IP every single day. They have hacking units that are sitting and doing that nonstop. It's not going to end. They want to dominate. They want to be the country that dominates the United States, as we all know. Sorry, I get that. Anyway, let me talk though about how to protect your companies. So a cyber incident by itself ordinarily will not give rise to a false claims action. Because it's the cover-up that will. So if your company does as it's required to do under 7012, cybersecurity incident occurs, within 72 hours you report it, you do the investigation, you preserve the logs, you figure out with the government if there's any compromise, what was compromised, and those types of things. And by the way, when you do the report, everyone knows this already. Although the smaller companies can't do it, they have to notify their primes. But you file it in the DC3 Defense Center, and I'm going to forget but it's DC3 is the abbreviation that we all know that you report it. And there's certain data elements that have to be included in that filing. So you file that, and then the government, you've done what you're required to do. Now, FCA, false claims actions liability arises where a company knowingly fails to comply with material requirements of the contract. So if you report, then you've now satisfied your obligations. But if you don't, if your company doesn't do that, that's where liability lies. And this, again, is the heart of national security issues and where I think we're going to see the most action. So let me just go back and talk about, I know Jacob really wanted me to talk about the importance of mid-level, mid-tier companies and smaller companies. And so where could they run into trouble? Well, your primes, the prime contractors you work for, they're not going to want to get in trouble, right? So if the government comes calling and saying, what happened with this? What do you think they're going to do? They're going to protect themselves. They're going to say, oh, my subcontractor filled out this questionnaire. Here you go. This is what I relied on in basically giving them the contract. And by the way, I gave them the flow downs. I told them what they had to do. And there is also, DOJ has policies to ensure that people cooperate. And you get credit from the government for cooperation. So it's in their best interest to cooperate with the government, to give them what they want, and to point the finger at somebody else, right? Okay. So that's one of the issues that people have to be aware of when they're thinking, oh, no one's going to find out about this. I'll just tell the prime and it's fine. No. The prime is going to likely report it because they don't want to be in trouble with the government. And you also get credit. So and I investigated companies all the time. They're going to want to cooperate. And they're going to also want to show the government, we did remediation. We took measures to ensure this doesn't happen again. Well, what do you think is going to happen to the subcontractor? Do you think they're going to get terminated? Yeah, they're gone. So it's in your company's interest to comply with the cybersecurity measures, or do your best to get, if you're not complying now, to move in the direction of compliance and to ensure that you still get those contracts in the future. The other thing that you should be aware of is the False Claims Act doesn't require that you show a specific intent to defraud. The government doesn't have to prove a specific intent to defraud. They have to prove that a false claim was made. What does that mean? All they have to prove is someone in the company had actual knowledge. They recklessly disregarded the falsity of the information. We often said, you do the willful blindness. They knew, but they're like, no, I don't know, I don't see, I don't know. But that's sufficient. They don't have to show the specific intent in this case. Oh, sorry. They're either there's someone with actual knowledge, deliberately ignorant, or they're recklessly disregarded. So those are three ways to prove knowledge in a false claims action. So this is my last slide. And if I didn't scare you already about false claims actions, so one of the things I wanted everyone to understand is so I was a prosecutor in the Navy JAG and then in the as I said in the government for a total of 22 years. I've done a lot of investigations, as many of the prosecutors have. And what happens when someone is investigated, often, is you don't just find the civil fraud that we're talking about, you uncover other things. And so if enough resources, the government puts enough resources into a case, what do you think they're going to find? They're likely going to find criminal liability. Are they going to find export violations? Again, a 20-year felony. Are they going to find obstruction? Obstruction is one of the easiest crimes to prove. All you would have to prove is that someone found out about an investigation and pressed deleted some records. That's obstruction. It's not, and if what should happen is there should be a litigation hold that the lawyers tell you to put on your records and don't destroy anything, but sometimes that doesn't happen. But there is a potential for criminal liability in this area between the SEC disclosures that I mentioned earlier, the new obligations under the Cyber Incident Reporting for Critical Infrastructure, Act of 2022 that are coming down the pike. As I think everyone knows, that so 16 industries were deemed critical infrastructure, which is virtually everybody, and it includes the DIB, so you're all included in that new reporting requirements. When I'm speaking about the cyber incident reporting, I do want to mention something in relation to the ransomware presentation we had earlier. Please be careful with ransomware, because there's this impression that you just pay the ransom. It's becoming so difficult because most of the ransomware attacks are being done by Iran, Russia, and China. In China, they're done by cyber actors that are on OFAC's list. OFAC is the Office of Foreign Asset Control. It's becoming very difficult. It's illegal for you to pay most of the ransoms. And now 2 states, Florida and North Carolina, have made it illegal to pay ransoms to the hackers. So that is that loop of like, oh, I'll pay the ransom and I'll be back in running. That is going to be becoming very difficult, if not impossible, to do. Okay, so last thing. So when federal government investigates a civil complaint, what will they find? I did not put on the list tax fraud, but we always find tax. I mean, the government always finds tax fraud too. Sometimes they don't prosecute that, but just think about that when you're talking to, you going back to do your presentations to your management, or you're talking to a client. What are they afraid the government will find? Because that's what's going to happen. They're going to be put under a microscope. With that, I have 9 minutes, well, or 10, if Jacob gives us an extra minute, for questions. And I apologize. I wanted to make sure I went through and gave you as much advice as I could.
All the way around to ask a question.
I was too late putting my hand up. So first off, thank you for this brief. This is awesome. So the False Claims Act, yeah.
Oh, thank you. Thank you so much.
As I said before, you're a legend. So.
Oh, thank you.
So the False Claims Act, it was established in 1863. So the question for you, with your experience, do you think that we're going to keep leveraging this act, or do you think that there's going to be a new law that's going to come out that's going to be more refined to help hold these organizations accountable?
So I think right now let's get into politics. I don't see this Congress passing a lot of laws. I'm very happy the CHIPS Act went forward because I do think that's really important for our supply chain. I think we should be manufacturing more in the United States, and that was bipartisan. I don't know that the Congress will be enacting anything new. And I do think that the False Claims Act it's a huge financial recovery for the government as well. And I do think that it really does encourage people to file, to report cyber attacks. And it also encourages to be more careful. Like if you're one of the people that is like basically certifying, or you're submitting the score in Spurs, you want to know that's as accurate because your ass is on the line. Sorry, I probably shouldn't have said that, but that's true, right? And you could be individually liable, not just the company. So I think that the way they're using the False Claims Act it is designed, and I think it will change behavior.
Question online was basically echoing the idea that they can't arrest us all, and the DOJ is limited on resources. Do you think that there is any indication of a major increase in resources to pursue FCA, civil cyber fraud? And is that, my twist on that is that a legitimate way of avoiding the things you just explained?
Well, I think there has been more resources put in, and the investigators that are doing these cases are going to be DCIS primarily, and Defense Criminal Investigative Service. They will be working with DOJ. The way that the act is written, if DOJ doesn't have enough resources for one case, the whistleblowers council can do it. So I think that this is actually, I do think there's been an increase in the cyber. They created new cyber squads at the FBI, and also HSI works on these cases too. And so there is a number of resources that have been directed to the cybersecurity problem and the cyber hackers, and they're going to work hand in hand. So I definitely think that will continue because this is a huge threat and it's not going away. There's some more questions.
So as a contractor, obviously it's when you made aware of the situation, you got 72 hours to report it. And to a prime, you report to your prime. Are you responsible to make sure they take it past that, or where does your responsibility stop?
So that's interesting. I had a case, a ransomware case with a person that wasn't a prime, was a sub. They didn't have the ability to file it with DC3, so I drafted a letter for all the basically the prime contractors that they worked with, and said, tell us what else you need. So I think that you are, and I would document it and say, you did everything you can, but there's certain things that a subcontractor can't do. And so that I think does relieve you of liability at that point. And tell us, what else you need from us. And they did a very diligent scrub. They, and hired a company to help them implement their cybersecurity. I wasn't retained until after the attack, so I wasn't part of anything that happened prior to that time.
Another question that we had online was regarding flow down mechanisms in contract clauses such as DFAR 7012, and specifically whether failing to flow down the requirements constitutes qualifies under these issues? And even more specifically, the relationship between a managed service provider and their client, which starts to get a little murky, in your opinion. How does that play
and
out?
that was interesting because I was talking to somebody earlier about the managed service provider and whether they could potentially be a whistleblower. And I was of the opinion that a managed service provider would not want to be a whistleblower because they're eventually going to be outed in the suit, and that all their clients would then not want to hire them anymore. But I do think that the primes have to put the flow down. It's their obligation to put in the flow down. That's what the contract says. That's what DFARS requires. And that would be their failure for not doing that. My understanding is that, subcontractors and primes work very closely together. They report things to their primes. And again, I just wanted to alert people, the mid-tier, smaller companies, that they could be reporting that back to the government because it's their interest to protect themselves. Now, let's be honest about one issue. Cyber attacks, everybody has reported this. It's not a matter of if you will be attacked, it's a matter of when. So I think that there is an understanding, and what my understanding is that when it's reported to the primes and your information was encrypted and you took precautions, that typically that there's a very limited downside to the reporting, and it's not like they terminate your relationship. And the government, I think, is understanding of that too. It's the failure to report and to take minimum cybersecurity steps prior to the attack. But encryption is critical. Do we have time for a couple more questions?
I got one. So do you think the false claims or like whistleblowers could actually be utilized as a strategy to remove companies as competitors? So if you have a former employer go somewhere else and then take you out?
I would hope not. I don't know that. I mean, then let's be honest. I mean, there's a lot of companies that do critical work that the primes rely on. There's established relationships, and it is, it takes a lot of money to be able to work for the government, things that you create. My hope is that that's not, and that was not the way that, one of the things that I thought was most important in when working at DOJ is always exercising good faith and doing what's in the interest of justice. I don't think that would be. And the other reason, and rationale, and this is more directly to your point, was DOJ said in its press release that they wanted to level the playing field because and not put the people that spend the money on cybersecurity at a disadvantage. And that by requiring everyone to incorporate cybersecurity would level the playing field so that no one was unfairly making more money because they decided to disregard the cybersecurity standards.
Okay, I think we have time for one more. And Stephanie, I think you'll be around after as well during the break.
I'm here for the networking session too this evening. So.
Perfect.
Hi. Given the fact that it's already known that there is a gap, especially for a lot of the smaller and medium-sized companies, is it really enough for a prime to just say they said they had it and not take any further steps in terms of protecting themselves? Or is that a little bit of the, burying their head in the sand?
Well, I think that the primes have, many of them have incorporated now questionnaires, that their subcontractors and their vendors have to complete. They also, the other thing that primes are worried about is depending on what access they have to the primes network, that they could be, and there was just an article recently about how that could be a vulnerability for the primes. So I do think that they're really going to start requiring that as a condition to continuing to do business with that company. And so I do, and the questionnaires, their documentation, they're going to be asking more questions, I think, in this area to ensure that everyone is complying. I hear you, though. I mean, it's costs a lot of money, but I think that in the end, that's going to help avoid having your network compromised by ransomware or a business email compromise, which we haven't talked a lot about, but that happens more frequently than even ransomware, and it can be just as devastating to a network.
Stephanie, thank you so much. Stephanie Siegmann, everybody.
Thank you.